we had the Fellows Christian Day School Incorporated, located in Decatur, Georgia. It's a private Christian elementary school incorporated in South Carolina, and it conducts a great deal of its operational activities in offices in both Florida and Georgia. In addition to prescribing a curriculum centered on Christian values and beliefs, its charter requires that its staff subscribe to a particular set of religious beliefs, including resolution of employment disputes according to a biblical chain of command. All employment contracts provide in relevant part, quote, all staff members must agree to present any grievance to the supervisor and to acquiesce in the final authority of the Fellows Christian Day School Board of Directors and forego pursuit of a civil remedy in court. Patty, who is 24 years old, was completing a paid internship at the day school. As a day school employee, she is required to sign the employment contract. The completion of the internship at the day school is a prerequisite for her master's degree in early childhood education at Georgia State. Patty has earned her undergraduate degree in child psychology as well from Georgia State. She has substantial student loans because her parents, who live in Florida, still claim her as a dependent on her taxes. As a result, she could not qualify for in-state tuition. She was born in Florida and lived there until she moved to Atlanta to attend Georgia State. Her college sweetheart and fiance, Brad, moved to North Carolina after earning his degree in finance. He has leased an apartment in North Carolina and has a position at Bank of America as an assistant branch manager. After proposing to Patty to apply for a transfer to the Bank of America branch in Georgia, Patty has applied for several teaching positions in Georgia and North Carolina. A month before graduation, Patty discovered that she was pregnant. Aware that this event would probably contradict day school's religious doctrine, she consulted a lawyer to determine her options. When the school learned that she had consulted an attorney, it terminated her internship for violation of its stated dispute resolution policy, and because out-of-wedlock pregnancies came into direct conflict with religious doctrines and set a bad example for students. Patty. All right, so if you look at the sheet that I gave you, sorry I can't use the overhead, in determining whether or not there's subject matter jurisdiction, it's pretty obvious that there's federal question jurisdiction, sort of. You see, you can argue both sides. The first one say yes because the First Amendment protects the right, its right to terminate the plaintiff if the claims arise under 1331. So since it's a First Amendment issue, meaning religion deals with the First Amendment, that's a federal statute, you can make the argument that yes, you can get the case in federal court, subject matter jurisdiction based on 1331 federal question. Again, because you're dealing with a constitutional amendment or a federal statute, which in this case is the First Amendment. So that's of course what the defendant would argue. The plaintiff, on the other hand, who remember she initially filed her case in state court, so she wants to keep her case in state court. So the plaintiff would counter that because the First Amendment is raised as an anticipated defense, remember in the Lane case, rather than the plaintiff in her complaint, it does not rise under the Constitution as a 1331 federal question issue. So I think the stronger argument is the plaintiff's counter argument that the First Amendment is an anticipated defense rather than the basis of the claim. But of course, in an exam setting, you get credit for both. But I just wanted to make sure that you see how federal question jurisdiction may apply to this particular scenario. Any questions about federal question jurisdictions? We're not going to talk about it again until we do our exam review. Okay, remember to apply to a treaty as well. Yes, Olivia.
Can you just very briefly go over anticipated defense?
Yeah, so it just means, so if I say there's a claim for negligence, and the defendant says, no, the reason I was negligent is because I was on FMLA leave, Family Medical Leave Act, I was on leave based on that statute. So the basic claim is negligence, but it's a defense that you're saying the reason you were allegedly negligent was because of the statute. So it's an anticipated defense. In this case, it's the First Amendment. So it just means that the plaintiff's claim is a state claim and has nothing to do with a federal, it means that the plaintiff's case is a state claim, so it's not based on a federal statute, it's not based on the Constitution, it's not based on a treaty. But the defendant defends themselves based on one of those things, meaning based on a statute, based on a treaty, based on a constitutional amendment. It's an anticipated defense. But again, to get the case in federal court based on a federal question, it needs to be based on a federal question. It can't be based on a defendant's defense to a lawsuit that's been filed against he or she. Okay. Sorry.
For the wrongful termination, wouldn't that be like under the Federal Civil Rights Act and perhaps state law? So
yeah, so for the Wrongful Termination Act, it's your choice. You can bring it based on a state employment law statute or federal Title VII review act. So keep going.
So you just make the argument both ways?
Yes, you just make the argument both ways. So the thing about civil procedure, like pretty much all your law classes with a few exceptions, some of the courts are pretty clear, like assault and battery, but it's never quite that cut and dry. Meaning typically you can't argue both sides, which is why you need an attorney in there and the judge will make the decision. It's very rare that it's just going to be one of the two. Again, not an essay in this class, so starting the first week in April, we'll just be doing practice multiple choice. I just want to make sure you understand the context before you try to do a multiple choice question. If you don't understand the law, you're going to get it wrong. But for future classes, the classes that do have essays, they want you to do what he said, and they want you to have a discussion with them. They want to see that you, and I'll get your hand in just a second, that you consider all the options in terms of possible claims, counterclaims, different approaches. Yes?
This is more kind of general. When we're answering short answer questions, like I love the way this is set up with different subheadings, but it's not written like full pretty paragraph style. Like, is this something that's acceptable to you?
100% yes. So if we have short answer, it won't be more than 5 questions, but I'll limit, like you can only respond in 5 sentences. So it'll be literally a short answer. All right. Cool. Okay, diversity jurisdiction. So we're going to remember we have in matters with these domicile or citizenship in the parties, whether it's plaintiff or defendant. I'm not going to go through and read that whole thing, but essentially arguing that the defendant, which again is day school, is domiciled in South Carolina because it's incorporated in South Carolina. Remember, businesses can have 2 domiciles, their place of incorporation or where their main operation is. If it's a small business like Cute Little Day School, they're probably going to have their main operations and place of incorporation in the same state. It just depends. And then as far as Patty is concerned, obviously is going to argue that Florida is not her domicile because she doesn't live there, and she hasn't lived there for the past 5 years and for the other reasons that are listed. And the same thing, so I'm not going to spend a lot of time on the domiciles, I'm just reading the facts that are already in the fact pattern, you can read that on your own. But what's important is in trying to determine diversity jurisdiction, you have to figure out their domiciles. So you're always going to look at the facts and make your strongest argument for whatever states are mentioned in the fact pattern. Here we have Florida, North Carolina, and Georgia. Again, you're looking at where they currently reside and their intent to remain indefinitely. So the intent to remain indefinitely is where the argument comes in. Well, does she intend to stay in Florida or Georgia or North Carolina? That's the fuzzy part. That's the not clear clear-cut response or answer. So again, in determining domicile for individuals, it's where they reside, where they intend to remain indefinitely, and then corporations have those 2 approaches. And whenever we're trying to determine diversity jurisdiction, so again, you're looking at the citizenship of the party, which is determined by their domicile, and is the amount in controversy over $75,000. Here it's $76,000, the answer is yes, that requirement is met. And then last but not least, you always have to make sure there's complete diversity, which again, it just means no plaintiff or defendant can be domiciled in the same state. And that's it. It's pretty easy. It's pretty easy, to be honest. Actually, well, I won't tell you how easy it is, but it's easy. I was going to say it's part of the street law program, like, so I know that they can do it even before high school. All right, so we love subject matter jurisdiction. Cool. Before we talk about the cases today, So I'm coordinating this program, right? And I need to make sure the room is full because I want it to be successful. It's today from 12 to 1 p.m. It's called Everyone Matters. It's part of the Diversity Committee's programming mandate from the dean. So I like good food, so it's Mark's Feed. It's pulled chicken, pulled pork, baked beans, potato salad, green beans, brownies, and sweet tea, lemonade. We can afford pop or soda depending on what part of the country you're from. I will have a civil procedure sign-up sheet. If you come, I will add, and it may not sound like a lot, but I will add 2 points to your final grade. The reason that matters is if you're on the border between an A and a B, those points matter because you know how the curve works. At some point there is a cutoff. If the room is completely full and you can't get in, then sign a sheet and I'm still going to give you credit for trying. But 12 to 1 today in this room. Yes, I'm desperate. Ding. Okay, so.
Professor, I think you got a contract at 12:05 from the
Of course, ladies, you want to be this. Come on, I'll have a sign-up sheet right there taped to that table.
He wants to buy.
But the food might be, you know, it's going to know that is, but no, you can't. Who do we have for contracts?
Paul.
Oh, he doesn't love me. He likes me. I'll tell him that you already. All right, Tabitha, are you ready today?
Yes.
Oh, you still look flustered. Why?
Huh? Oh, I'm just going back to April because I read through.
So Tabitha, I'm going to ask you 8 questions.
Oh, okay.
Yeah, the only reason I'm asking you today is because you had the traffic issues last time, and so we really didn't get to it.
Yeah, no, you're
Yeah,
fine.
okay, so no 8 Yeah, you look flustered. I'm like, please don't be. It's like nice, chi environment, right? It should be by now. Come on, you're almost done with the semester. You're 2 L's, basically. 1 L's in the flesh, 2 L's in the mind. All right, so my choker is not going well.
That's too early.
I'm okay with that. I don't see a difference.
We'll let you.
Oh, that's exciting. To me, I'm competitive. Are we upset about the Louisville basketball game?
Nope.
Yeah, the lady parts are still in it. What was the Cinderella team? Murray State for a minute? Did you go to Murray State? Okay. So, certainly like that. So who's left?
UK.
Michigan State.
The Sparks are still in it? All right, go green. Anybody else? The Spurs, at least, are we to the Final Four yet?
No, Sweet 16.
Sorry, first of all, I'm a college football person, so I watch basketball.
Oh, Florida State's in it.
Yeah, I know that. So no, it's
Virginia Tech,
Okay.
Florida State, Tennessee, LSU, Michigan State, Oregon, Houston.
Is Oregon a wild card?
Yeah, they're low.
Yeah, so would they be considered the Cinderella team?
Yeah.
So I like when it's a smaller school like a Murray State. I love those. That's what gets me all excited. I'm like, oh.
I was looking for Wofford.
What?
Alrighty. Alright, so we left off in the last class talking about the Iqbal case in Standard 8A2. The rule of law for Iqbal, just as a reminder, is that in deciding when to grant defendants 12b6 motion to dismiss, again, which challenges the plaintiff's failure to satisfy Rule 8A2, the court will use the new standard, which is the plausibility standard, meaning the plaintiff's complaint must allege facts that plausibly support, meaning it's more plausible, is likely to have occurred, the plaintiff's claim, such that the court can make a reasonable inference that the defendant is liable. So again, the plausibility standard requires that the plaintiff's complaint must allege facts, not legal conclusions. So must allege facts, not legal conclusions, that plausibly support the plaintiff's claim, such that the court can make a reasonable inference that the defendant is liable. Reasonable inference. All right. So our next chapter. Oh, I should have left that up. I didn't have that up there. Sorry. So our next chapter, chapter 6, I believe, deals with additional pleading requirements that are required for certain types of cases. In addition to the general plausibility standard that we saw in the Iqbal case, there's also some additional pleading requirements depending on what type of case it is. So we're going to cover the Stratford case because it highlights some of these special rules under Rule 9. And so today, oh, I wish I had my list. Keep disappearing. So we've got Attorney Douglas, and we have, what do you call it? Have I called you Attorney Walsh yet? Yes. Awesome. Have I called on you Attorney, I think I've gotten everybody almost, yay. Bearden? Sorry. All right, so Bearden it is. Douglas Bearden. And since we have a lot of cases today, what about Attorney Healy?
I'm gonna for class.
All right, you want to make sure you emphasize first class. But remember, you did really well, though. That was a really hard case, so you should be happy about that. Because I did not do well in that case in law school. I didn't understand it.
I'm going through it.
You want volunteer to be tribune?
I'm good.
That's no fun because the whole point is you're supposed to know you're prepared. That takes away the.
Okay.
All right, so we've got Douglas Bearden and Baxter. If I'm calling you?
Yeah, you are calling.
Okay, so I think I almost got everyone, so I'll finish up the last few weeks. All right, let's go then. Bearden and Douglas. Which of you are kind enough to give me the facts, please?
Again, Dr. Stratford is a dentist who maintains an office in Staten Island, New York. He's failed to pay required insurance premiums for his building, and Northern canceled the policy from October 10th, 1999 to December 13th, 1999. And then December 6th of the same year, Dr. Stratford submitted a no claims letter, meaning that he had no reason to use the insurance until October 19th. And on December 14th, 1999, he was notified by the insurance company that the coverage would be canceled. Oh, never mind, sorry, wrong date. He was notified of reinstating it on January 9th, 2000. And then 10 days later, he made this huge claim on leaking in his building and his equipment being damaged and so forth.
Okay, excellent. All right, so I'm just going to highlight what she said to make sure everybody heard it. Thank you for being detailed with the dates because they are relevant. So this dentist we know is super shady, right? He's trying to get away with some insurance fraud. And it's so ironic. I have a family member who got mad at his wife, right? And called the insurance company to separate their insurance policy. They each have a car, and he said, I want it separated. We're separated. Didn't tell her. And so then they ended up, I guess he thought he was going to leave and decided that he was going to stay, but he forgot that he separated the policy, and he had it going to a friend's house, the new policy. And so he got what? Ran from the back on his birthday. Brand new 2019 truck. And he called, got a police report, called the insurance company, just not even thinking, because I'm like, how could you not realize that you hadn't, good morning, got your, that's okay. I'm like, how did he not know he wasn't paying the bill? And she said, oh, it's been an automatic withdrawal, you know, out of debit. And he thought he did, but he didn't. And so he called to make the claim with State Farm. They're like, you haven't been covered. He did it November 15th. Since then, January. So the accident happened March 8th. And so he lies and says, I never canceled my policy. So State Farm calls my cousin, the girl, and she's like, they left a message. What should I do? Like, you know, she's like, I didn't even know that he was planning on leaving me. She's like, so now she wants to like screw him over, right? But yet they're in this happy space. So she's just like, she's all confused. And she's like, I gotta call them back. And so, you know, the insurance company called her and she said, did you separate the policies? Well, no. Did you know they were separated? No. Okay, so it wasn't your intention, so she did lie because it's insurance fraud, and that's all they asked her, and she hung up. So now they're trying to decide, the underwriters, you know, basically he's saying it was a mistake. I never said to do that. Why would you do that? I mean, we're married. Why would I split the policy up? And they say we have here in our notes the customer service rep that took the call that you asked for because you said you're getting separated. You were separated from your wife at the time. So it'll be interesting to see what State Farm does. I feel like this shady doctor. He's outside the claim period, and you know, don't do the coverage. And so this dentist is like the shady cousin's husband. He basically allowed a policy covering his business premise to lapse. The weather turned poorly. The pipes in his office, as Attorney Douglas stated, burst and damaged most of his office, including some really, really expensive dental implants. And so he responded by asking the insurer to renew the policy. Again, offering written assurance that, listen, during the lapse, there's been no type of damage or incidents that have happened. And then, of course, right after the policy is renewed, shady dentist files a claim alleging the damage occurred a month earlier than it actually had within the time period in which he was covered under the policy. What went really south here in this particular scenario is that the dentist made a very bad tactical error, by upping his claim, as Attorney Douglas alluded to, from $150,000 in property damage to more than $1 million. And you don't think that's going to wave a red flag? Are you kidding me? And allegedly lost profit. So surprisingly, the insurer paid. I would have. But with this interest apparently peaked by the larger claim, meaning over $1 million, they continue to investigate the situation to see whether or not they should have just claimed coverage. So who sued first? Attorney Bearden. Sorry.
Plaintiff dentist sued the dentist in state court because they didn't pay $1.5 million.
Excellent. Yes. So dentist Stratford sued in state court. I believe it was $1.2 million. What did the insurance company do once it sued? And then I'll go back to Attorney Douglas.
Once he sued, the defendants removed the action to federal court and filed several claims.
Excellent. Okay, so what the insurance company did in response to the dentist, the plaintiff suing them, is they counterclaim for fraud. They're like, screw you, this is fraud, we're not paying the money. And they sought to recover the amount already paid, plus punitive damages. They wanted to make an example out of him, you know, for trying to fraudulently get this claim paid for. So what did the dentist do next, Attorney Douglas? What type of motion did he file? So because you didn't brief, we're waiting on you to find it in the book. Yes, I'm assuming?
I book briefed, I didn't get that part though.
We'll just wait on our turn here. So again, Stratford moved to, what type of motion did he file in response to the insurance company's counter?
Stated that they used Rule 9B and said that they failed to identify the lie that he had made.
Very good. Okay, so filing a motion to dismiss the counterclaim. They're like, hey. He's like, throw this claim out, Your Honor, because this claim again for fraud, because they failed to properly apply Rule 9B, meaning they failed to plead the fraud with the necessary specificity, right, required by Rule 9B. So I have behind me what Rule 9B requires. Essentially, it says, in alleging fraud or mistake, a party must state with particularity, so you have to give greater detail. You can't just be fraud and say, oh, there was a fraud claim. The circumstances constituting the fraud or mistake. Malice, intent, knowledge, and other conditions of a person's mind may be alleged generally, but the fraud, you have to be very specific about what fraud you're alleging occurred. So there's essentially two parts to Rule 9B. The first part being that for fraud claims, you must plead with particularity the specific circumstances which constitute the fraud. So again, the first part of 9B is that you must plead with particularity the specific circumstances which constitute fraud. One last time, the first step for Rule 9B is to plead with particularity the specific circumstances which constitute the fraud. And second, you can allege malice and knowledge generally. So it doesn't have to be specific. You can allege malice and knowledge generally. All right, so 404. Attorney Douglas, according to the court, what does the first sentence in 9B mean? I think it's on the last paragraph on page 404. According to the court, what does the first sentence in 9B mean? Meaning the circumstances surrounding the fraud was plead.
It requires the time, place, and nature of the alleged misrepresentations.
Excellent. So we like that because it's telling us what it means instead of being all vague. So you just means you have to state, as they stated, the time, place, and nature of the alleged representations. In applying that standard to the facts, what does the court conclude about the defendant's counterclaim? Then Attorney Douglas, and we'll go back to Attorney Bearden after that.
They said it was insufficient under Rule 9B and had to be dismissed, but they gave them a period of time to amend the complaint.
Now you're back in rockstar mode. You worried me. I was like, she's going to make me be an ASS. I don't want to be. So I need to know you're prepared. Excellent response. All right. So we know the court says that the defendant's counterclaim simply failed to identify a statement by the shady doctor that they claim to be false. Thus, it's unclear from the face of the counterclaims whether the defendants asserted that Dr. Stratford's claim losses were improperly inflated, or that the office was never flooded, or not during the term of the policy. So they're like, we need to know what specific fraud is. It all three, but you need to state in the counterclaim with specificity what particular fraud happened, the time, place, and manner. So they really didn't emphasize the manner or the time. So it just wasn't clear enough. And as a reminder, the court says that Rule 9 is there. The reason we have it is to provide the dentist, even though he's shady, Dr. Stratford, with fair notice of precisely which statement or which aspect of the claim they're saying is fraudulent. Okay, because again, the reason point for Rule 9 is number one, to help weed out frivolous fraud cases, to not overwhelm the docket, and B, if you're being accused of fraud, I need to know enough specificity so I know how to defend myself, right? Attorney Bearden, what does the court say about the defendant's complaint in the second sentence in Rule 9B, which is the top of 405? What do they say?
Well, this would say that the second part of Rule 9B is not sufficient.
Okay, I think you're perfect to say it one more time. We're almost done.
Basically, that the second part of Rule 9B, the complaint is sufficient.
Excellent. And it's sufficient why?
Because it states that fraud has occurred.
Excellent job. All right, so the court says the defendant's counterclaim counterclaim succeeds in alleging that the facts, quote, and this is directly from your text, give rise to a strong inference of fraudulent intent. The timing, they said, of Dr. Stratford's claim, again, just 10 days after the policy was reinstated, his alleged refusal to cooperate with the insurance company's investigation, and the size of the claim, from $150,000 to $1.2 million, is enough to satisfy that requirement for Rule 9. So in terms of the court's holding, we know that the court, in this case, agreed that the counterclaim, again, was not sufficiently specific, but they basically just gave the insurance company's lawyer a brief lesson on how to fix the problem, and granted him leave to amend the counterclaim, leaving Stratford without his dental implants and facing a very long and unpleasant litigation ahead of him with a particularly bad outcome. So when the court essentially saying, look, we're acknowledging that you did not follow 9B in terms of your counterclaim for fraud, but we're not going to just totally throw you out on a limb. We're going to say, you know what, go back, fix it, refile, and we can move on with the litigation. So it's not trying to screw people over that have legitimate claims, meaning the application of Rule 9B. It's just trying to make sure the process is fair, so that even though Dr. Stratford is shady, that's for the jury to decide. He has the right to defend himself, and he needs to know with specificity, time, place, and manner of the claim, so he knows how to prepare an efficient or sufficient rather defense. So this is Rule 9. Do we like Rule 9? I do. Like, even if I'm being shady, it's kind of like everyone has the right to counsel. Like, I still want to know how, what I should be defending myself from. And I don't want any, I want to be prepared as possible. So that's all Rule 9 is doing for us today. All right. The next topic that Chapter 6 deals with is allocating elements of the claim. Okay, so allocating elements of the claim. So far, we essentially assumed two things in this class. That we or the court knew the elements of each claim, or kind of claim, and we've assumed basically that the plaintiff had responsibility for pleading those particular claims. And we've assumed that because if you're the plaintiff bringing the lawsuit, I'm assuming that you are responsible for pleading or arguing what the claims are, the different elements. So, interestingly enough, Chapter 6 tells us that neither of those two assumptions are necessarily always true. Sometimes the court is not sure who has the burden of pleading particular elements of the claim. But how does that relate then to Rule 8A2, right? Who has the burden of proving the elements of the claim can also impact whether or not the party has fulfilled 8A2. Remember that 8A2 requires the party to provide a short, plain statement showing that you're entitled to relief. And a part of that showing that you're entitled to relief is making sure you plead and address the specific elements of each claim that you're asserting. So the Jones v. Block case, which we will cover next, basically addresses the issue of who bears the burden of proof, or rather proving different parts of the claim, and how that impacts 8A2. So again, we are reading the Jones v. Block case because it tells us who bears the burden of pleading different parts of the claim, and how that burden impacts our 8A2 analysis. All right? Okay, so you did great with the facts last time, so do you mind giving us the facts, Attorney Douglas?
No problem. Lorenzo Jones was a prisoner held in Michigan prison. He suffered an injury while he was in custody and asked to be relocated to a job that would not aggravate his injuries, but the staff refused to reassign him and told him, do the work or suffer the consequences. So he did the required tasks, and it ended up aggravating his injuries. So he sued under 42 U.S.C. Section 1983, and his case was consolidated with other complaints that are similar.
Excellent job. All right, so the issue then in this case is that, as you say, the court consolidated this case with several others to decide who had the burden of pleading exhaustion of administrative remedies as required by, again, this newly enacted Prison Litigation Reform Act, which, again, requires exhaustion of administrative remedies, but does not address who has the burden of burden of pleading. So a quick side note on the exhaustion of administrative remedies. So several federal statutes will require that you exhaust your administrative remedies before you can file your case in federal court. So for instance, the EEOC, Equal Employment Opportunity Commission. So if I am here at UofL, if I feel like I've been discriminated against because of my gender on the job, I didn't get tenure because I'm a girl, they don't want any more women tenured faculty members here, right? I can't just go and file a case in federal court. I can go and file a case in state court anytime I want. But federal court is probably going to give me a little bit more bang for my buck for a couple of reasons. One, state court, localized. They're not trying to, they love UofL. It provides a lot of employment for the city. The judge who's going to be hearing my case is going to be caring about re-election. If there's a big lawsuit in favor of me where the university has to pay me out, that might not be looked upon favorably. I want to go to federal court with that issue, right? And so in doing so, I have to, if I want to file my claim under Title VII, which is an employment discrimination statute, I have to first exhaust my administrative remedies with that at my place of employment. So that means I have to go through the EEOC first. That's exhaustion of your administrative remedies. And I have to let them do their investigation, and they're going to ask me, did you file a grievance at your place of employment? Yes. Did you go through their process? Yes. They said that's not why I didn't get tenure, but they're lying. So the EEOC will do an investigation, and then they'll give me a right to sue letter. That right to sue letter, I can then go to any attorney here and say, I'd like to file my case in federal court, and they're going to ask me, do you have a right to sue letter from the EEOC? Or did you go through the EEOC's process, meaning did you exhaust your administrative remedies? And I'll say, yes, they'll file a case in federal court. Now, I can exhaust my administrative remedies through the EEOC and still not get that right to sue letter, and still file my case in federal court. But the point is, the idea is it's kind of another gatekeeping mechanism, another layer that you have to go through, and what the hope is behind including that requirement in statutes is that, we'll handle stuff here, and we won't have to go to federal court. Meaning my job will say, oh, we don't need a lawsuit, let's go ahead and rethink this, or they're offering me a settlement. So again, it's just another way of trying to minimize the amount of cases that are actually going to federal court if they can be settled and handled at a lower level. Most employment law attorneys are going to want that right to sue letter because it's basically kind of a stamp of approval. They're like, well, the EEOC says they have a valid claim, let's go. But the EEOC looked into it and said, it's very hard to get a lawyer to say, okay, yeah, I'll take your case. But you could always find someone if you're willing to pay them, I guess. All right? So that's what they mean by this exhaustion of administrative remedies. And so the issue that the court has to decide in this case is, does the plaintiff have to provide facts in the complaint that it has exhausted its administrative remedies, or is it an affirmative defense? Who can tell me what an affirmative defense is? Yes?
An affirmative defense is a defense that the defendant has the burden of proof. They have to prove that it's actually what the case is.
Absolutely textbook perfect, yes. So that's the question. Sorry, I threw me off a little bit because you were so precise. So yes, the plaintiff has to prove, so I can't talk today. The court's trying to decide whether the plaintiff has to provide facts again in the complaint that it has exhausted its administrative remedies, or is it that an affirmative defense that the defendant needs to allege in their answer? Hey, the defendant would say, hey, their plaintiff just filed this case against me. They haven't even exhausted their administrative remedies. They haven't fulfilled that requirement of the act. So I need you to dismiss this case, Your Honor. So what specifically, Attorney Bearden, does the exhaustion provision of the Prison Litigation Reform Act provide? I think it's on page. So what specific exhaustion remedy does it provide? I think it's on page 411. You can take your time. No, it's on 410, yeah.
It says that no action shall be brought with respect to prison conditions under 42 U.S.C. Section 23 or any other federal law by prisoner confined in any jail, prison, or other correctional facility until such administrative remedies are available or exhausted.
Perfect. And what's the court say is the purpose behind this Prison Litigation Reform Act? Why do we even have it?
Basically, they just don't want to flood the courts with
All right, so yeah, so basically just to address the large number of prison litigation complaints filed in federal court. To that end, Congress basically enacted a variety of reforms, again designed to help filter out some of the bad claims and facilitate a smoother process for legitimate claims. And so one of the key features among these efforts by Congress was the requirement that inmates complaining about prison conditions, again, exhaust their prison grievance remedies before initiating a lawsuit. Because you know every prisoner, not every, but most of them will be like, I'm being treated poorly. So like, we just want legitimate claims here. So requiring exhaustion basically allows prison officials an opportunity to resolve disputes concerning the exercise of their responsibilities before being hauled into court. This has potentially reduced the number of inmate suits and also to improve the quality of suits that are filed. Who in here has seen the movie? It's super old. It's okay if you don't know what it is, but Shawshank Redemption. Oh, no way. That's so cool. Isn't that like such a cool old movie? Like, I love it. Every time I do this case, I think about Shawshank and how he totally screws the warden over. But you can see why this Prison Litigation Reform Act is trying to keep out illegitimate claims so that ones like we saw that were obviously very legitimate in Shawshank Redemption can actually get to the court system. All right, so the court's holding in this case was what, Attorney Douglas and Reese?
They said that most courts view failure to exhaust as an affirmative defense, and because claims covered under the PLRA are typically brought under a statute which does not require exhaustion at all, they found that that it would be beneficial to go with the majority of courts on this case, and that the defendant would have to prove that they had exhausted all of the other avenues.
Excellent, excellent, and excellent. So, any questions about this case? Any questions? Pretty quick cut? Yes?
I just want to make sure I have the holding down correctly. So they ruled that the burden of proof for failing to exhaust administrative remedies is on as the defendant's suit. That's what the prison officials ruled.
Yes. Okay. Excellent. All right. Moving forward. You look so fun today, Journey.
Like the boy out of your mind.
It's the material, not me, so I'm not fitted. All right. So moving right along, we're doing really well. The last section covered is ethical limitations in pleadings. You're seeing all these exceptions to that initial Rule 8A. So ethical limitations in pleadings. And so Rule 11A provides, as you see there, and Attorney Olivia, is it Rick's will attest that I will send this PowerPoint to you. She asked for it a little bit early. Me with all this stuff in it. So if you see me moving along, I'll send the PowerPoint. I just want to get through today's class so that we can get through all the cases before I send it out. Rule 11A provides that every pleading, motion, and paper filed in federal court must be signed by an attorney of record or for parties not represented by lawyers and by that party. Okay, does anyone know what Rule 11B provides? Can someone tell me what Rule 11B provides? Voila. It's long, that's why I'm emailing to you. All right, so Rule 11B basically says that an attorney or the unrepresented party certifies that allegations made in the complaint were formed after an inquiry reasonable under the circumstances, and that to that person's best knowledge, the information and belief that 1, the complaint is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2, when you sign that complaint, you're asserting that the claims, defenses, and other legal contentions are warranted by existing law and is not a frivolous argument. And then 3, the factual contentions have evidentiary support. And then 4, that the denials of factual contentions are warranted on the evidence, or specifically so identified, are reasonably based on belief or lack of information. So the whole purpose of Rule 11 is to promote a litigation environment where you have ethical pleadings. Don't plead, frivolous, crappy stuff just to get the case in court because you're trying to harass your ex because you're mad at them, when you know that it's really, you got them hiring an attorney, wasting their time, when you know it's not a legitimate lawsuit that you're filing. So Rule 11 is trying to hold you accountable, and what they will do is, if you're found in violation, the judge can say, you know what, you're going to pay for the other party's attorney fees for wasting the court's time, and we're going to give you a fine for wasting our time as court, and you're going to pay their attorney fees. So Rule 11 is there to try to, again, weed out frivolous, pointless, unauthentic lawsuits. And then lastly, there's 11C as intact. C as intact. It's there. It is. Yay, distinctions. All right. Provides after notice an opportunity to respond. The court will determine that Rule 11B has been violated, and then they can impose some of the sanctions that I mentioned before. So essentially what happens is a party seeking sanctions will give notice to the other party that, look, if you don't change this or if you don't drop this lawsuit, I'm going to seek sanctions. So you basically give a copy of that motion to the defendant, and you give a copy to the court, and then you wait 21 days. And if they don't withdraw the complaint, the plaintiff, ooh, did y'all just hear something quiet? Are you guys joking with me, or you didn't hear like a buzzing sound stop? So I look crazy. Okay.
I still hear a buzzer.
So what just happened when I was talking to you, so you almost remember that I'm rattling here. But while I was talking to you, it sounded like when you're on the airplane and then your ears unpop, and so all of a sudden I went from like tunnel to this clarity, and I was like, did y'all hear that? So that's what happened. So yeah, so basically Rule 11, all I care about the, in the number of days, because you can look that up in the statutory book of your attorneys. It's 21 days you have to respond before, if you don't, then the judge will look at the motion and make a ruling. I care about that 11C are the sanctions that can be asserted if you violate 11A or B. Let's go ahead and talk about the Walker case. We are doing so well. We're right on time. I'm happy. Attorney Bearden, let's try you with the facts.
So, in the dispute over a minor trust fund,
I'm going to reframe that. Just tell me the basis of the lawsuit for the sake of time. Yeah, sorry about that.
Basically,
What's Walker claiming?
Walker's claiming that he breached a fiduciary duty and other state law causes of action against more companies and needless individual officers and boards.
Excellent. All right, you're doing like judicial job, like Judge Bearden level. Just rockstar. Do you like the content in this class? It's okay if you don't.
Yeah, I like it because it's like code based almost.
Yeah, so you're going to incorporate?
I don't really know, but I'll work at CPA right now.
Oh, that makes sense. Because I hated the class as a student. I like it now because I'm on the other side, but I didn't like it. I just thought it was too vague in the beginning, so I lost interest and never kind of checked back in. So we know the basis of the lawsuit. This Penoyer, I'm like, what is that? Like, what is that crap? And I just checked it out until the end. The basis for the lawsuit is he stated plaintiff. Walker claimed that the defendant and his officers, as he stated, improperly handled the trust fund, so they breached their fiduciary duty. The plaintiff and his guardian, which is going to be Cynthia Walker, are both South Dakota residents. And the defendant, Northwest Corporations, is a Minnesota corporation. So far, that means that we are good on diversity jurisdiction. Yay, we like that. So what then is wrong with the plaintiff's complaint?
They said that the plaintiff and some of the defendants are citizens of different states.
Yes, so they're implying that on the face of the complaint that there's no complete diversity, right? They're saying, hey, wait a minute, diversity is incomplete. Some of the defendants were also South Dakota residents, and so was the plaintiff. So that's what's going on here. So they're saying you're being unethical. You're trying to file a case in federal court based on subject matter jurisdiction, and there's not diversity of citizenship amongst the parties. So what does the defendant do when he realizes that there's something wrong with the plaintiff's complaint? He does what every defendant would do. The defendant pounced on that basic first-year student mistake and sent the plaintiff a letter asking him to withdraw the complaint or you face sanctions. So there's a student I used to have come and speak. He's been too busy this semester, but I'm still begging him. His name is Rudy. I forgot Rudy's last name. Rudy Ellis, thank you. Rudy loves to tell the story his first year in practice that he found a complaint that someone filed and realized that they didn't have diversity jurisdiction. He's like, are you serious? He thought it was a trick because it was too easy, so he went ahead and filed a motion for sanctions, and the person's like, screw you, there is diversity jurisdiction. He's like, no, there's not. And so he went before the court and argued that they were really, the plaintiff and one of the defendants were residents of Kentucky because their intent to remain indefinitely was here in Kentucky, and he won. He's like, I won. He's like, this is like an older attorney. He's like, I totally won the motion. So he loves to tell the story. He tells it better because he lived it, but it does happen. So we know the plaintiff's response to the defendant saying, withdraw the complaint or face sanctions is after plaintiff's attorney, Massey, failed to offer any explanation for the defective issues in the complaint. The defendant, Northwest, moved to dismiss under Rule 12b1, lack of subject matter jurisdiction. And so what does the court do then? So I had mentioned those Rule 12, and we will spend a class talking about them, but Rule 12 are different reasons, again, that you can do a motion for dismiss, whether it's here it's lack of subject matter jurisdiction, lack of personal jurisdiction, and so on. And so the district court basically said, look, we're going to grant the 12b1 motion to dismiss and sanctions, so they gave sanctions to Attorney Macy under Federal Rule 11 of a total amount of $4,800 in fees and expenses. So the Walkers and Attorney Macy appealed the decision. Attorney Bearden, what did the plaintiffs do wrong in this case? What did the plaintiffs do?
Basically, they just didn't understand that required complete diversity of jurisdiction.
And furthermore, what else did they do wrong, Attorney? Wow, have a moment, don't say your name. Douglas.
They didn't look into it at all to see where everybody was from.
What's the biggest thing they didn't do outside of look into it? Once they were put on notice, what didn't they do?
Oh, they didn't even change it.
Yeah,
They acknowledged it, but didn't change it.
Yes. So they brought the complaint on his face, suggesting again this absence of this is what the plaintiffs did wrong, absence of jurisdiction. And then they failed to correct the mistake when it was brought to their attention. Who does that? That is like ridiculous. And so what could the plaintiffs have done to correct the problem? It would have been really easy just to drop one of the individual defendants, right, and add them when they decided desirable. So they could have dropped one of the defendants to create complete diversity. And I know this is kind of like manipulative, but you can always add them later on after the suit has. That's Civ Pro too. You can be sneaky and kind of add them as an additional defendant later on, or they can intervene on their own via Rule 24 because if the outcome of the case is going to affect them personally. So if you have a co-business partner, let them intervene later on via Rule 24 to get in the case, even though it's going to destroy diversity. There's like all these exceptions, but just know that that's why it's a chess game. It's like who's going to outsmart the other person. So it's a lot of strategy involved until you get to the actual jury to view the case. All right. So what section of Rule 11 did the plaintiff's counsel violate? It's going to be section 11b1. I don't think I put on the slide. It's going to be section 11b1. Yeah. So that's what section that was violated. Section 11b2. That's the section that was violated. So it says under that provision, counsel has obligated to do enough research to know that the diversity jurisdiction alleged in the complaint required complete diversity. 11b2, as you have behind me, provides that the claims, defenses, and other legal contentions are warranted by existing law or by non-frivolous argument. So this claim of diversity jurisdiction was not warranted by existing law because existing law requires that the plaintiffs and the defendants be domiciled in different states. So it's 11b2 is the section of Rule 11 that the plaintiff's counsel violated. It's also probably a violation of 11b3, right? To continue to advocate for diversity jurisdiction when the plaintiff's counsel became aware he had no evidentiary support for citizenship of some of the parties, and the evidence that he did indicate some of the defendants were residing in South Dakota. So he could easily point to nothing other than a hope and a prayer at this point that these defendants would turn out to be diverse to the plaintiffs. So he basically had no evidentiary basis from the beginning to believe that the allegation of diversity was likely to have evidentiary support. So again, 11b3 could apply as well because he continued to advocate for this diversity jurisdiction, even though it was brought to his attention that there really wasn't a strong basis for that. So we're on appeal here in either Attorney Douglas or Bearden. What were Attorney Macy's and the plaintiff's arguments on appeal? They're still kind of ticked off. Thank you.
They tried to say that they shouldn't have had to go through all the effort that would have required, even though it wasn't much effort. And they also tried to argue that they didn't have the money to pay the sanctions, and that the plaintiff never argued for sanctions, so why were they getting them?
All right, and Attorney Bearden, excellent everything. Do you have anything to add? If not, that is cool.
No.
All right, so we have essentially what they're saying on appeal. I'm just going to highlight some of the stuff that Attorney Douglas said. That Rule 11, essentially, they're like, look, it doesn't require this kind of complicated, in-depth analysis, and they said it's possibly. They just didn't think it was necessary to have to dig that deep for the defendant's citizenship before filing the complaint. That's a really weak argument. They also said they felt that the district court abused its discretion in awarding monetary sanctions since dismissal of the complaint would have been adequate. So why are you giving us sanctions? Just dismiss the complaint. But we don't have the money. You're now going to make us pay $4,800. Just throw the complaint out. They said the court should have inquired into the attorney's financial situation. They would know they didn't have $4,800 to pay. That second argument, isn't that ridiculous? That is goofy. So I'm supposed to inquire to your financial situation to see, no, we break the rules, I'm going to apply the sanctions. But that's their argument. And they said that the district court based its discretion in denying the request to amend the complaint, abused its discretion when they said, you know what, we're not going to allow you to amend the complaint. Now remember, in the previous case, the court was a lot nicer and said, you know what, we're going to allow you to amend that 9B insufficient part of the complaint, and then you can move on. But here, they're like, this is so basic, and this is like the basic due diligence that attorneys should do. We're not even going to let you amend the case. Like, this is ridiculous. Yes.
That'd be like malpractice.
Yes, 100%. So she asked a great question. Could this be considered malpractice? Yes, the plaintiff could bring this up through the ABA, and this person could possibly get disbarred because they've just gotten screwed because of the attorney's inadequacies.
Well, yeah, and I was just going to say, like, one of my favorite quotes from this case is the district court is not obliged to do Massey's research for him, especially at such a late date.
I love that. But Massey says, yes, you should. You should be my legal clerk, right? And that's a great quote. I'm glad you said that. So we know the court responds to these arguments, these very weak arguments, in saying that the plaintiffs are basically arguing that finding out the defendant's citizenship would be more trouble than they should be expected to take on. However, the court says this is the burden of the plaintiffs that are desiring, again, to invoke diversity jurisdiction. That's your job as an attorney, essentially. As to the attorney's inability to pay the sanctions, the court says that the attorney failed to argue that point to the district court, and there's no record or evidence to support that argument. I don't even think they should be able to argue they can't pay the sanctions because I think it's a good deterrence for you not to do that if you know you're going to get sanctions regardless of whether or not you can afford to debate them. I don't break the rules. It's kind of, you don't want to go to jail, don't run the red light, you know, unless you're me. Just kidding. I don't run red lights. That's bad. You don't want to die. But yeah, so the district court, they basically said they're not obligated, as attorney does, to do the plaintiff's research or lawyering for them. So the court says no abuse of discretion and upholds the district court's decision against the plaintiff. Awesome. We've done really well. So like we're like on schedule. We are 7 minutes ahead of schedule. I'm so excited about today. And that's it. So tomorrow is Tuesday. So we will continue on with our discussion. And I think that's it. I'll see you soon. Bye. Oh, the tennis sheet. Where is it? I got it. Okay, you can leave it there. I'll come get it.
I am, you are. Yes. Alex Erland. I know you concentrate all day. Yeah, no, Elizabeth. Oh yeah, not to see. No, not it. Like, I make friends over there. How much your room? Is that your dress? I'm gonna go see. I need another.
Well, it's also like since we have to do the parlay. Yeah, because it's not fair because prisoners already don't have tokens.
So you're taking.